This case has all the makings of a courtroom thriller: high stakes, legal maneuvering, and a $20,000 pot sitting right in the middle. On one side, the plaintiff is demanding their rightful payout, claiming every penny is owed due to occupancy. On the other, the defendant says, "Wait just a minute, that money belongs to us." And just when you think it's a straightforward escrow release, the judge drops clarifications that change the entire playing field. Over the next few minutes, we'll break down how an appeal gone wrong, a battle over property taxes, and one final cutting remark from the judge turns this into a lesson in responsibility. Stick around, because the ending, it's jaw.
Where are we on this?
Your Honor, this is our motion to seek distribution of the funds held in the court's escrow account related to this case. Just to recap, two $5,000 payments total, which was the lease payment amount, incidentally, were placed into the account pursuant to the standard escrow order that was entered during the pendency of the case in chief. And then subsequent to the issuance of a judgment of possession, there was an appeal, and Your Honor entered another order, a bond on appeal, yes, under which two additional $5,000 payments were made into the court's escrow account. I've confirmed with the clerk that $20,000 is currently being held. There was an appeal, obviously, hence the appeal bond. That appeal was dismissed by the Washtenaw County Circuit Court. There was a subsequent appeal to the Court of Appeals that was processed as an appeal of right when in fact it should have been otherwise, and that court dismissed the appeal. So there are no pending appeals on this matter, Your Honor. The matter is final and closed, and as an administrative act.
Here's the legal reality. When a court orders funds into escrow, that money is essentially frozen until the case reaches a legal conclusion. The plaintiff here is saying, "Case is done, appeals are over, give me the cash." That's a textbook request once all appeals are exhausted. The defendant, however, is muddying the waters by introducing other issues: security deposits, property taxes, insurance payments, which, while potentially legitimate claims, aren't tied to this specific escrow. Viewers, here's a question. If you had $20,000 sitting in court, would you fight for it even if the law wasn't on
action? I would ask that the court authorize the distribution of those monies to my client. Thank you.
Well, according to MCR 3.31, this was an injunctive bond that supposed to protect both of us because we counter-complained against.
Why was it it wasn't an injunctive bond.
It should have been, because we applied for restraining order against the plaintiff and it wasn't granted. But this plaintiff case still is in pending status with federal court, and we paid $10,000 security deposit. We want them back, and we also paid over $44,000 of expenses that we paid the property taxes, we paid the homeowner's insurance, we update and upkeep, and they even charge us attorney fees, Your Honor. And I have the sheet to prove it, and therefore we are entitled to this $20,000.
This is where emotion starts mixing with legal strategy. The defendants listing every expense: property taxes, insurance, attorney fees, in an attempt to justify keeping the $20,000. The problem: the judge can only rule on what's before the court. Bringing in unrelated costs might sound compelling to the audience, but in legal terms, it's like trying to argue about a speeding ticket by saying you paid your car insurance on time. It's important, but it's not the case at hand.
Why don't we get clear, first of all, what the $20,000 is? The $20,000 was escrow pursuant to the basically summary proceedings action that had been filed. That is not under Section 3 of the court rules. That is actually under Section 4 of the court rules regarding the issuance of an escrow order. I issued that order. You complied, as counsel has indicated, with 2 months of that. Albeit late, there were 2 payments put in. Judgment was rendered. You appealed that judgment, also pursuant to the court rules. in, again, Chapter 4, you will see that the bond on appeal, I could have set it theoretically at whatever or whatever bond, but where there has been an escrow order, that escrow order then effectively becomes the bond on appeal. And that's what happened. And so then there were two additional payments prior to the dismissal of the appeal that then makes the 20,000.
Listen closely here. The judge is breaking down why the $20,000 exists in the first place. It's tied to lease payments during possession, not to damages, repairs, or deposits. This distinction matters. When you're in possession of a property, during a dispute, you often have to keep paying, as if the lease is still active, even if you're fighting eviction. It's one of those legal realities that shocks people. You can be in the middle of a lawsuit and still owe full rent.
So that we're all, whether we're not on the same, we can all be on the same page or not. That's what happened, and that's why the 20,000 is there. I don't know what you're talking about in terms of injunctive relief. I don't know any of that. That has nothing to do with me in this court. The purpose of that, and the 5,000 was the amount of the lease, basically the lease price of the premises.
Exactly.
All right. You were in possession of the premises up until such time as the writ. I don't know if the writ has been executed or not.
And the return has been filed by the sheriff.
Got it. So you would have had to have paid that amount to be in possession of the premises up until whatever point in time and during appeal. So I'll let you make additional argument, but it seems to me that the 20,000 should be paid over to the plaintiff because of your.
Notice the shift here. The judge is essentially telegraphing her ruling by stating the $20,000 should be paid over to the plaintiff. She's telling both sides where this is headed. This is often a strategic move. A judge might preview their thinking to give each party a chance to add any last-minute arguments before the hammer falls. But unless the defendant produces a bombshell piece of evidence, the writing's on the wall.
Occupancy of the premises.
Permission to speak, Your Honor?
Go ahead.
What about our security deposit, Your Honor? What about the payment of property taxes and homeowners insurance they forced us to pay in anticipation of the sale, which they breached the contract and they never did, Your Honor?
This is where a lot of tenants get tripped up. The security deposit and the escrow funds are completely separate legal entities. Security deposits are governed by a specific statute, with their own timelines, rules, and penalties. The judge here is making it clear. Wrong case, wrong time. If you're a tenant, remember to get your security deposit back. You have to follow the legal process outlined in the Deposit Act. Bring it up in the wrong case, and it won't even be heard.
That would have to be taken up someplace else in terms of the property taxes and whatever. In regard to the security deposit, the security deposit is the disbursement of the security deposit is taken care of pursuant to an entirely different statute.
I beg your pardon?
There's the Security Deposit Act, which governs is how that gets returned and or not returned, what it can be applied to. That's not before this court.
Which court is this before, Your Honor?
Pardon?
Which court should I go and ask for return of?
I can't give you legal advice. I'm just saying that issue, I'll put it this way, that issue is not before the court. That has not been raised as the return of the security deposit. Usually is something that takes place after the tenancy. Sometimes it's dealt with during the course of a summary proceedings case, certainly, but that has not been raised here and is not before the court.
I'm raising that today, according to ex parte emergency motion and filed, Your Honor.
I don't know that it would be, I don't know that all of the compliance, the act is very specific about certain things that have to happen in order for an issue under the Security Deposit Act to be right to even be heard before the court. I'm not even sure all of that's happened. You can't just say, I need you to deal with this. That
You can hear the judge's patience thinning. The defendant is trying to wedge unrelated claims into the discussion, but judges operate under strict procedural boundaries. If it's not raised properly in pleadings or motions, it's essentially invisible in the courtroom. This is a common mistake, thinking that just because you're in front of a judge, you can bring up anything and get a ruling. Not so. The courtroom runs on process, not personal priority lists.
that's not how it works.
I petition again, Your Honor.
Well, you can do what you want, Ms. Staffeld. I'm just telling you, I'm not dealing with the security deposit. It's not before me. The only issue before me is the $20,000 as an escrow and its disbursement. Is there anything else you want to say?
Thank you for evicting me and my
This is the emotional climax. The defendant thanks the judge for evicting me and my family, adding a God bless you, clearly meant to sting. But the judge fires right back, flipping the blame squarely onto the defendant's own. No compliance. This is classic courtroom drama, raw emotion versus the cold letter of the law. And the judge delivers a life lesson while making a ruling. Take responsibility for your own actions, or the system will hold you accountable anyway.
family out of our house, Your Honor. God bless you.
Well, I guess you're welcome. I didn't evict you. You evicted yourself by not complying with the lease. So
That's-
don't try to put that on the court. Sometimes people, when they have problems in life, have to take the responsibility for their own actions and can't sit there and try to blame the plaintiff or blame the court or blame everybody else in the world. Those are the people that have real problems because they can't take it on themselves to do the right thing. So to the extent I made you realize that, you're welcome. It's the order of the court that $20,000 will be paid to the plaintiff. Counsel for the plaintiff prepare that order so that I can then give that to the clerk and we can disperse that.
Thank you so much, Your Honor. Appreciate your time.
We know this is gonna happen, so we are submitting this right now.
Thank you. Ready? Here's us. I was waiting for you to sit down so I could cause real problems since you'd have to get right back up. No, I'm kidding. All right. Karen Steele versus Robin Piach.
Anything to make your day a little easier, Judge.
Judge Dominic Camden appearing on behalf of the plaintiffs.
And Ashwin Patel, Student Legal Services, appearing on behalf of Robin Piach and Billy Piach, Chase Piach. The other defendants are present as well.
So can we approach?
Are you okay, sir?
Can we approach? Yeah.
And there you have it, $20,000 released to the plaintiff. The defendant leaving with nothing but a hard reality check. The appeals failed, the legal process played out, and in the end, the original lease obligations held firm. This case is a reminder that in court, procedural correctness often outweighs emotional pleas. If you've ever been in a legal dispute over money, you know just how high the stakes can feel. So, what do you think was the judge fair here?